So hi everyone, welcome to FedSoc's last speaker event.
Am I the last one?
You're the last
Oh,
one
save the
here.
best for last, right?
You did. You're our grand finale. I want to remind everyone that elections for next year's board are up and running, and they'll close this Saturday. So please head over there and vote. And next, I want to take a minute and just recognize some people. First, I want to thank all of you who have participated in our chapter this year. I hope they've been fun. I hope you've learned something, and I hope that you'll come back next year and be more involved as well. I also want to thank those that have served on the board. Scott, Matt, Phoebe, Will, Ryan, Wyatt, and Nick, thank you so much. You put in a lot of hard work, and it wouldn't be possible without you. And lastly, I want to say a massive thank you to Shiza. I literally couldn't have done any of this year without you. Thank you so much for the 100+ hours of behind the scenes work that you've done. And now we'll get started with our event. And I have the pleasure of introducing Professor Josh Blackman. He is a national thought leader on constitutional law and the U.S. Supreme Court. His work was quoted during 2 presidential impeachment trials.
Back to back.
He has testified before Congress and advises
Undefeated.
federal and state lawmakers. He regularly appears on TV, and he's also a frequent guest on NPR and other radio programs. He's published commentaries in the New York Times, Wall Street Journal, Washington Post, and other national publications. Since 2012, he served as a professor at the South Texas College of Law, Houston. He holds the Centennial Chair of Constitutional Law. Professor Blackman.
Call me Josh. Call me Josh. It's actually better. Please.
Josh Blackman.
Thank you.
Is also an adjunct scholar at the Cato Institute. He's authored 3 books. He's also the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
And Professor Richard Finneran is a partner at Bruin here in St. Louis. His practice focuses on white-collar criminal matters, corporate internal investigations, corporate compliance, and appellate trial and civil litigation. He was also the Democratic nominee for candidate for Attorney General in Missouri in 2020. Prior to re-entering private practice, Professor Finneran was an assistant United States attorney for the Eastern District of Missouri, where he was integral in prosecuting the largest criminal fraud in the history of the Eastern District. He also prosecuted investment fraud, embezzlement, Ponzi schemes, securities frauds, tax evasions, cyber crimes. The list goes on and on. Professor Finneran has also tried several cases in federal court and argued numerous appeals in the U.S. Court of Appeals for the 8th Circuit. He was the first winner of the Adjunct Professor of the Year Award by the Student Bar Association at WashU in 2013 and received the award again in 2017.
And last year.
Well, we
There you go.
haven't updated the website.
All right, okay.
They retired the award.
In addition to co-teaching appellate advocacy here at WashU, which is a fantastic course I recommend to everybody, he also coaches the Wiley-Rutledge Moot Court competition, the National Moot Court team, and the Admiralty Moot Court team. He has led numerous students to national championships, and he has an invaluable presentation that everyone else gets to hear during their spring semester. He received a BA from North Carolina University and his JD from WashU, where he graduated magna cum laude, Order of the Coif, and Order of Barristers. So without further ado, we would like to start the program, but I would also like to thank Jocelyn, who has also put in hundreds of hours when she should just be relaxing as a 3L. So please let me give her a round.
Thank you. It's so good to be here. I was last at WashU in 2019 or so, right before COVID. So none of you were here. Memories fade, but this was in the exact same room, so it's good to be back. Topic today is the Second Amendment. In the span of 2 years, the Supreme Court decided 2 landmark Second Amendment cases. District of Columbia v. Heller in 2008 held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to militia service. And 2 years later, the court decided McDonald v. City of Chicago. This case applied the right to bear arms to the states via the 14th Amendment. The precise holding of both cases, however, was limited to the issue of whether the federal and state governments could prohibit the private ownership of handguns inside the home. Heller and McDonald did not address a broader question. Does the Second Amendment guarantee a right to carry a firearm outside the home? Over the ensuing 12 years, the lower courts would divide on this question. Then the court decided in 2022, New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N. The Supreme Court held that the Second Amendment does protect an individual right to carry a firearm outside the home. Now, what was this case about? Brandon Koch and Robert Nash were law-abiding citizens in upstate New York, Rensselaer County. They were members of the New York State Rifle and Pistol Association. Koch and Nash both wanted to carry a handgun outside the home to defend themselves, but New York required more. Specifically, applicants needed to demonstrate they had, quote, proper cause, that's the term in the statute, proper cause to carry a firearm. Koch and Nash had to show a special need for self-defense that was distinguishable from that of the general community. It was not enough to show that they lived or worked in a high-crime area, rather than to provide evidence of particular threats, attacks, or extraordinary danger to personal safety. New York had a law that was known as a may issue regime. I'm guessing Missouri shall issue, I'm just guessing.
I think that's right.
I think that's right, okay. New York had a may issue regime. That is, a state may issue a carry license at its discretion. By contrast, more than 40 states, I think Missouri is among them, has what's called a shall issue regime. These regulations say the government shall, that is must, issue a carry license if a person meets certain objective criteria, such as passing a criminal background check or taking a training course. Now, Koch and Nash did not have a special need that was distinguishable from that of the general community. They simply wanted to carry a firearm for self-defense. Therefore, a judge in New York determined that they did not demonstrate proper cause. Their licenses were denied. And the lower federal courts upheld the denial of these licenses. The case was appealed to the Supreme Court, and the court reversed by a 6-3 vote. Justice Thomas wrote the majority opinion, which was joined by the Chief Justice and Justice Alito, Gorsuch, Kavanaugh, and Barrett. They joined entirely, not in part, entirely. Justice Breyer wrote a dissent, which was joined by Justices Sotomayor and Kagan. The case involves 5 primary issues, which I want to walk through with you now. The first issue is methodology. In the decade following Heller and McDonald, the lower courts often reviewed gun control laws for the last decade. Very, very seldom was strict scrutiny actually followed. Justice Thomas's majority opinion, though, rejected any means ends balancing test. No scrutiny. That's not what we're doing anymore. Instead, the court favored a test rooted in the Second Amendment's text as informed by history. Specifically, who has the burden? I'll tell you something. In common law, if you have the burden, you're probably going to lose. The court placed the burden on not the individual seeking a gun. The burden was placed on the government. The government had the burden to affirmatively prove that its firearm regulations is part of historical tradition that delimits the outer bounds of the right to keep and bear arms. Okay? Then the court will assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. Justice Breyer dissented, and he repeated many of the same notes he played a decade ago in Heller and McDonald. He says judges are not equipped to resolve difficult historical questions or to perform searching historical surveys. For example, during oral argument, Justice Breyer said that Heller was in conflict with historical evidence. There are piles of briefs this high from historians across the country saying Heller was wrong. In McDonald, there are professors of history who ran departments in the English Civil War who said the history was all wrong. Breyer said, this is a wonderful case for showing both sides, but I'm not sure how to deal with this history. Now, what would Breyer do if the evidence was in tension? The court should defer to the government. Likewise, Justice Sotomayor said during the oral argument, history and tradition is that states get a lot of deference. Justice Thomas and the majority disagreed. In his view, the court resolved legal questions rather than resolve historical questions in the abstract. And when the parties present the court with a historical record, courts can decide which party made the stronger case. Now, we're already seeing in the aftermath of Bruin, judges are sort of saying, no, Thomas, we don't agree. At least one judge in Mississippi wants to appoint an expert witness to recount historical facts. Other judges are soliciting amicus briefs to explore various historical questions. So the Thomas's assurance that judges don't do history has not been picked up by a lot of the judges in the lower courts. Okay. The second issue is really what the case was about, right? What is the scope of the Second Amendment? Does that amendment extend outside the home? Curiously, New York didn't really disagree. New York sort of conceded that the Second Amendment extends outside the home. They just disagree on the permitting requirements. Justice Thomas explained that the Second Amendment does not draw a line between the home and the public. There's two rights. There's a right to keep arms and a right to bear arms. And the word bear in the Second Amendment naturally encompasses carrying, public carry. Confining the right to bear arms to the home would nullify half of the Second Amendment's operative protections. Moreover, where does self-defense occur? Where confrontations occur, which are generally outside the home. Therefore, the court held that the Koch and Nash have a right to bear arms in public for self-defense. But that part, again, wasn't really disputed. The question is whether New York's may issue regime was constitutional. Right? New York said, sure, there's a right to bear arms inside the home, but we can restrict it to those who have a special need. How would the court decide if the may issue regime was valid? The court turned to what they call analogical reasoning. Analogical reasoning. Do you all remember the LSAT from a couple of years ago, right? If this is to this and this is, remember those questions, right? Yeah, it's coming back in your brain, I'm sure. Justice Thomas said we need to see if there's some historical regulation on carrying arms that is similar, relevantly similar to what New York is doing today, right? What is the analogy? Is there some regulation in history that would form the basis for this regulation today? What do we analogize New York's law to? And this is where a lot of the historical analysis plays in. Again, there were briefs stacked this high of historians on both sides arguing that yes, there's support for this, no, there's not. Curiously, though, and I'll say this point in candor, no one advanced this analogical reasoning. Not a single amicus brief on the side of the plaintiffs argue we need to do analogical reasoning. Thomas just sort of made this up. I don't know where he got it from, but he got it from somewhere. And no one wanted it. In fact, a lot of original scholars don't agree with the framework Thomas used. I'll get to that a little bit later. But Thomas looked for potential analogies in 4 periods of time, epochs, if you will. The first, we go back to medieval times, not just for jousting and eating chicken with your hands, right? This was a period of time. Did they have medieval times in St. Louis? No?
No.
Nah, that joke fell flat. Okay. They're fun. It's fun if you ever go to one of them. We look to laws from medieval to early modern England. One of the big examples was from 1328, the Statute of Northampton, which I'm sure you've all studied in your 1L classes, right? This law was enacted during the reign of King Edward III. Really important guy, right? What did this law do? The parties did not agree on this question. Paul Clement was a lawyer for the plaintiffs. He said that the Statute of Northampton prohibited carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public. In other words, it was only a crime to terrorize the public with a weapon, but carrying a normal rifle would not have done that. New York disagreed. Barbara Underwood, who was New York SG, said that carrying a gun would, by definition, terrorize the public, per se, if you will, right? Guns were deemed to be offensive weapons, thus carrying was always prohibited. Again, there's reams of evidence about how the statute was enforced, how often it was actually being implemented, what kind of weapons were barred, but ultimately the court said that the statute only prohibited bearing arms in manner to spread terror among the people. So at least going back to 1328, only those who carried a gun to terrorize others were regulated. If you did it in a lawful manner, it was okay. That's what the court held. Then we go ahead to the American colonies in the early republic. There's little evidence of regulating public carry in this period. But prior to the Civil War, in antebellum America, states began to enact restrictions on public carry. But none of these restrictions were analogous to New York's Maysh regime. Thomas wrote, at most, the manner of public carry was subject to reasonable regulation, but the states did not prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public. Then we get to that after the Civil War. And that's actually where a lot of gun control laws emerge after the Civil War. Thomas wrote that after the Civil War, Southern states violated blacks' rights to keep and bear arms. But he said these racist Jim Crow laws were not reliable evidence of how the right to bear arms was understood. And in 1866, Congress reenacted the Freedmen's Bureau Act. This statute expressly authorized the Bureau to protect the constitutional right to bear arms. So at least those who framed the 14th Amendment thought that bearing arms was a fundamental right of a constitutional nature. Justice Thomas wrote that other limits on carry were consistent with the right of public to peaceably carry handguns. But there is some contrary evidence, which Justice Thomas sort of brushes by. There were Western territories. Maybe you've seen these posters. You know, when you get to a town in the Wild West, surrender your gun with the sheriff. You've seen these posters everywhere, right? Some Western territories prohibited carrying pistols altogether. How does Justice Thomas deal with this? Not the best. He says the court dismissed these laws, quote, which appear more as passing regulatory efforts by not yet mature jurisdictions in the way to statehood. So he sort of said this was the Wild West. It was rough and tumble. They were sort of figuring things out. We can't use these as strong evidence to counter all the other evidence on the other side. All right. So then Thomas concludes, American governments simply have not broadly prohibited public carry of firearms. But then we get New York's law, which is over 100 years old, right? It's in the early 1900s, as part of the Sullivan laws. So one of the tricky parts of this case is what is the relevant historical period? A law that's 100 years old was perhaps insufficiently old. Laws from the Wild West were fleeting, but laws from the Revolutionary era and earlier are dispositive. It's sort of this like Goldilocks. This is too new. This is too old. This is just right. But there's a serious question about what's the relevant time period. And in fact, Justice Barrett wrote a concurrence questioning, when we're talking about the 14th Amendment, is the relevant period 1791 or 1868? And the court said, either way, it's supported. Okay. But then we get to the fourth part of the opinion, which is where sort of the originalism goes out the window, and it's sort of frustration for me and others, where the court identifies limits on the holding. These limits are not grounded in text or history. It's limited in the Rule 5. You know this rule? It's an important rule in the court. You got to keep a majority. And if this part wasn't there, you would lose the majority. So the Rule 5 is a very important rule. You may remember in Heller itself, there was this paragraph that said, we do not question long-standing prohibitions of the right to bear arms, you know. On violent felons from have dangerous weapons. We can't have unusual weapons. We can't have people who are criminals having guns, right? We can't have guns in sensitive places. We have all these sort of restrictions. Bruin did not cast doubt on any of those caveats from Heller. In fact, it reaffirmed them. The court also did not cast doubt on the shall issue laws in 40-odd states. These laws, which require background checks and firearm safety courses, were deemed objective, so they were okay. Thomas suggested that these regimes were put towards abusive ends. It may not be okay. So, for example, in some states now, I think in New York and San Francisco, you have, I almost called them a fine, but a fee of almost $400 to get a license. And you have to wait up to a year to get a license. I suspect these fees are way too high. That's more than the administrative cost. It's basically a penalty at some point. And waiting a year is just far too long to get your license. So there'll probably still be litigation over these issues. These are sort of peripheral. Justice Kavanaugh, who's the court's sort of swing vote, wrote a concurring opinion, which was joined by the Chief Justice. And he identified two other limits in the court's decision. First, Kavanaugh wrote that states can require background checks, firearm trainings, as well as a mental health records check. A mental health record check. That was not an issue in the case. He sort of made that up on his own. And let me tell you, you've seen the numbers. What percentage of people now actually visit mental health professionals? High number. Whether you care about guns, I don't care. Do you really want the government looking at mental health records? Whatever you think about guns, fine, right? There's an issue of commitment or domestic violence restraining orders, but if someone had a diagnosis of depression 20 years ago, do we really want bureaucrats leafing through that? In New Jersey, there's an entire cottage industry of psychologists who just sign off on this. That's their job. They charge you a few $1,000s, and they'll write you a letter saying, I think this person is safe to have a gun. Most doctors won't touch it. They're afraid of liability. So you have to basically go to these specific doctors who have a practice and insurance with the corporate lawyer sitting next to me, willing to take on that, right? Willing to take on that liability. It's actually very expensive. It's not easy, and only a few of them willing to do it. Most doctors say, I'm not signing this paper. You think I'm going to put my license in the line for you? No way. But he wrote, again, mental health checks. Kavanaugh also repeated verbatim the paragraphs from Heller that approved of longstanding prohibitions on firearms by felons and the mentally ill and sensitive places. What's a sensitive place? That's issues being litigated now. In the wake of Bruin, New York City designated Times Square as a sensitive place. And that's basically this 20 square block area in Midtown Manhattan where you can't carry. There's signs everywhere. Now, unless you live there or some other need, you cannot bring a gun into that area. There's still plenty of guns there. Don't worry. Just not people with concealed carry licenses are bringing them in there. Okay. The final part of the case turns to what you might call policy. Justice Breyer's dissent had all these sort of statistics about how many people have been killed with a firearm and numbers on mass shootings. And he criticized the court for severely burdening the state's effort to reduce gun violence. For Breyer, judges should exhibit modesty and restraint when they interpret the Second Amendment. Justice Thomas emphatically rejected this approach to judging. He quoted from McDonald, "The right to keep and bear arms is not the only constitutional right. That's controversial public safety implications." Think about it. The Bill of Rights is full of dangerous things. Rights for criminals, right to counsel, not in there, but Miranda, right? Exclusionary rule. These are all principles that result in the bad guy perhaps getting away and not being punished for his crime. Thomas wrote, "The court should exhibit unqualified deference to the right of law-abiding, responsible citizens to use arms and not the legislative interest." So in the wake of Bruin, I'm almost done, I promise. The courts will have to decide a range of issues. And I'll just list a couple of them here. One is what kinds of weapons are prohibited. Prior to Bruin, the courts upheld bans on so-called assault weapons, high-capacity magazines, and various other types of accoutrements, noise suppressors. They're called silencers. It doesn't make the gun silent; just sort of reduces the noise. And otherwise, people are nodding. Yeah, it's not like the music, pew pew pew. No, it's loud. If you ever find a person who does target shooting, they're deaf, right? They can't hear anything because it's so darn loud. So the suppressors help with that. Another issue that we litigated is the scope of sensitive places. Scope of sensitive places. A number of cities have designated entire swaths of their city as a sensitive place. I don't think that's going to survive. Schools, government buildings, and so on, those are probably off limits, but public sidewalks will probably remain, I think will eventually be deemed not a sensitive place. Now, the trickiest of these cases is the rights of former felons, violent misdemeanors, and people subject to something less than a misdemeanor. So, for example, a domestic violence restraining order. And we'll start there. About 2 months ago, the court of the Fifth Circuit, where I am, decided a case called Rahimi. It's Rahimi, Rahimi. And this case involved a person, not a very nice person, who had been engaging in domestic violence issues, and he had 2 restraining orders put against him. He was never convicted of a crime, so there's no misdemeanor or felony in his record, but he was subject to a what's called domestic violence restraining order, the DVR, domestic violence restraining order. I always forget the acronym. He sought to have a gun, sought to have his gun rights restored, and the Fifth Circuit ruled in his favor. A 3-judge panel ruled that there's no historical tradition of denying people the right to bear arms based on domestic violence restraining order. Right, and in a sense that's true because there was no such thing as a domestic violence restraining order like a couple decades ago. That wasn't a thing. So the Solicitor General took the unusual step of skipping en banc review. Usually, if a three-judge panel rules against you, you seek en banc review. SG didn't waste your time. It's Fifth Circuit. It was not a productive use of paper because if anything, it would get stronger on appeal. So the SG filed, like, I'm not joking, a couple weeks later, a cert petition. These usually take a few months, right? They have 90 days. You got a cert petition a few weeks later. I think the court will probably grant, I think they have to, striking down a statute. Rahimi, it's a circuit split issue also, I think. They'll probably grant Rahimi, we're now, what, April? They'll probably grant it in September or October when the new term starts. So we'll have this case in the docket for next year. Let me tell you why this is important. If you are a gun rights activist, what is the worst case to put on the post-Bruin docket? Domestic violence restraining orders. That's the case you do not want. If you are the U.S. government, what's the first case you want on the docket post-Bruin? Domestic violence restraining orders, right? If I'm a Second Amendment litigator, which I am, I do litigate these cases. I want a case of, wow, San Francisco's charging $400 for a license. That's way too much money. That's the case I want. It's nice, it's smooth, everyone's, no criminal history. Or I want, you've designated all of Midtown Manhattan as a sensitive place. That can't be right. So what I suspect will happen is Rahimi will go up along with something else that's a little bit less icky, to use a very good legal term, right? And the court might just split the difference. That is, the court might say that the Rahimi case was wrong, that people with propensity for violence will, in other words, there's a tradition of banning those with the propensity for violence, and the lower court sort of messed up the scrutiny level, right? And in the same case, they'll say, well, but you can't have these sort of arbitrary restrictions. You have to wait a year for a license. You have to pay a $400 application fee, which is more than what the actual paperwork costs. And when you have a government application fee, it's supposed to cover the cost of the government, not to make them money. That's not what this goes. That's not the purpose of a permitting process. It should be. But I think that the lower courts will still wrestle with this sort of text and history approach. And I would be surprised if Justice Thomas writes the next majority opinion. I love Justice Thomas. I'm a fan of his always. But I think that he sort of went on his own with this one, where he adopted a standard that not a single Second Amendment litigator wanted, and now we're starting to grapple with it. It also has implications elsewhere, right? If we get rid of scrutiny in the context of the Second Amendment, we also get rid of scrutiny in the context of the First Amendment. Right. This is a sweeping argument that we get rid of scrutiny. We basically turn common law upside down. So there are a lot of things to consider. But I think we'll see next term of the Supreme Court, Rahimi and maybe one or two other gun cases. So the court got a very brief respite of barely a year between the Second Amendment cases. All right. That's all I got. I welcome some questions and comments, and we'll talk later. Thank you all so much.
Well, thank you. I think I was designated in the advertisement as the respondent, but I don't intend to really respond too much. I'm more interested in what your questions are, and I may have a question or two of my own, but I know we only have probably another less than 20 minutes to engage in questions. So really, why don't we start to see if there's any questions from the group, Ms. Moss?
So my question is about the application of the Bruin standards. So I think this is one of the articles that we're publishing in volume 101 of the WashU University Law Review happens to be about the use of territorial law in the new Bruin age and how Justice Thomas kind of just pushes it aside. Yet when we have territories, when we compare territories versus state law, territories were subject to the restraints of the federal constitution much sooner than states were pre-incorporation. And so I guess what I'm curious, I've looked at a couple of Second Amendment cases after, even after Heller, but after Bruin, and just seeing the way that they apply the history. A lot of it is just based on what the Supreme Court has adopted in those cases. How do you think that upcoming litigators, and people like us who are going to be associates slogging through law firms if we're dealing with these cases, how do people research for these? How is this a work, like how can like, can it be a workable standard in lower courts, or is it just going to be courts making policy and making these historical judgments in a way that cannot be principled and uniform throughout the country?
Thank you. There's a lot in the question. I'll try to unpack it as best as I can. The first question about the territorial standard. Let's just be charitable to Justice Thomas for a moment, right? Let's say that there's a 700-year tradition of the government not prohibiting carrying of arms by law-abiding citizens. But in the last part of the 19th century, for about 20 or 30 years, you had some territories that were basically rough and tumble. They were on their way up. And they decided to, we have no law enforcement. We have no wide earth, right? We have no sheriff running around. Let's just try this for a little bit. And no one litigated it. There were really no courts back then of any stature. How do we balance 20 or 30 years of a nascent jurisdiction trying to settle itself in the wilderness versus a 700-year tradition? Right. Again, I'm being charitable for a moment. So it's not insane to brush aside the laws of the territories to the extent that they were consistent with everything else. By the same token, we have the Jim Crow laws, right? A lot of the gun control laws were designed to disarm Black people. There was no doubt about that, right? The southern states wanted to lynch people. They didn't want people fighting back. This is true. This happened, right? The Freedmen's Bureau Act specifically guaranteed the right to bear arms to avoid that. So what do we take as the baseline? Is it the racist Jim Crow law designed to disarm Black people? Or is it the Freedmen's Bureau Act, which said, no, you have this right to bear arms? So I think the struggle in Bruin was saying how much weight we put in various pieces of history. Now, for better or worse, Thomas made that decision. I think that issue sort of settled. But now going to the second half of your question, how are, bless you all, right? How are young lawyers supposed to actually deal with this standard? Fortunately, I think a lot of this will be resolved in the next couple of years, so maybe you'll be spared it. I think the Supreme Court will have to decide once and for all the issue of violence, right? The court might say, you need a felony conviction. If you don't have a felony conviction, keep your gun. Now, of course, a common law, you all know this, what was the only penalty for felony? Death. Right? So again, people who were executed didn't have much need for a gun, right? Because they were dead. They were executed, right? There were not many misdemeanors. The idea of a misdemeanor is actually a fairly, I'll say novel, that's the wrong word, but there weren't that many misdemeanors. Say there were a lot of misdemeanors. The issue of domestic violence, right? At common law, a husband could beat his wife. That was allowed. That was actually up to a certain standard. That was actually permissible. So not only was domestic violence not a crime, it was actually sort of encouraged. So in what universe would that person be denied a right if it was permissible? Today, we don't allow that. We don't allow domestic violence. Domestic violence is bad, right? So I think the standard the court will probably draw is one that Judge Barrett drew in the Seventh Circuit during her very, very, very brief tenure. She had a case involving a guy called Ricky Cantor who was engaging in Medicaid fraud. He had these little insoles he put in sneakers, and it was fraud, right? And he billed Medicaid for them and whatever. And what Barrett said in her dissent in the Cantor case was that if a person hasn't shown any propensity for violence, there's no history of disarming them. I can see 5 votes for that, right? Martha Stewart, right? Why can't Martha Stewart own a gun? A white-collar, nonviolent offense probably be allowed. But if you had some sort of violent offense, even if it's a misdemeanor, even a domestic violence restraining order, you're probably outside the scope. So I think the court will have to clean it up very quickly. We can't have you're a former federal prosecutor sitting next to me. You can't have a circuit split on federal criminal statutes. That's not sustainable, right? So I think they'll clean this up quickly. You might also have Congress modifying statutes to make clear the predicate offenses to indicate there is actual crime of violence. What's tricky is when you have these state offenses, those are harder to sort of modify and apply, but Congress may try to clear that up. But very, very good question. Thank you so much.
So my question is sort of a follow-on on the Second Amendment rights of domestic abuse victims. I'm thinking specifically of the Supreme Court case that was during Justice Scalia's last term that was reversed, the Massachusetts taser case.
Oh, the taser case, yeah.
Yes. And things that will come up like financing for firearms and how the states that are trying to prohibit basically access to things like that. So I just want to get your analysis on if that is your plaintiff, what would you argue and how would that fit into this Bruin analysis?
Okay, so you're speaking about the victims of violence?
Yes, when they try to own firearms.
Well, I think they're in pretty good standing now, post Bruin, because right, they have the right to keep a gun in the house, and they have a right to keep a gun outside the house for carry without having to show any special justification. So the victims are actually doing pretty well. The question is about the assailants, right? What are the rights of the former assailant, those who inflict the violence on others, to have some sort of rights restored? I mean, another way to actually do this would be the Attorney General actually has discretion to restore gun rights, right? And so this doesn't have to be done through litigation. The Attorney General could just simply say, for nonviolent offenses in federal prison, we're going to restore your gun rights. So the AG could do that, and Congress will have to fund that, but that's actually another possibility. And in fact, there's some political accountability there. Fun fact, I mentioned this guy, Ricky Cantor, who had the Medicaid fraud in the gun case. Trump pardoned him. I don't know how this came about, but of all the people that Trump pardoned at the very end, towards the end of his term, he pardoned the guy that Barrett wrote a dissent on. I have no idea how that came about. I have no clue. Like, total coincidence.
Yeah, so I'm sure you're familiar, but 25 states right now are at constitutional carry.
Yes.
So is the standard from Bruin only applied to restrictions, or is there a potential for it to be applied to sort of, I guess, grants or allowances, like allowing people to conceal carry without a license at all?
Well, the tricky part is traveling, right? So if Missouri, or I live in Texas, we have constitutional carry in Texas, and the number is about 20. I don't know the latest total, right? What happens if I have a carry permit in Texas, but then I'm traversing through, other states that don't have those regimes, right? Is there an argument under the Privileges and Immunities Clause of Article 4 of a right to carry, right to travel? And before you say, of course not, Josh, abortion, right? Can Texas criminalize going to California to perform an abortion? One of the responses is no, because of the Privileges and Immunities Clause. So there's actually this sort of weird double standard where a right to travel protect both abortion and guns, or neither abortion nor guns, or perhaps one or the other. So I think the issue of the right to travel is tricky. And what you'd have to have is a prosecution where a person was licensed in state A, travels to state B where he's not licensed, and he's arrested for illegal carry. And then he could raise his defense of right to travel issue. There may be an argument that the 14th Amendment demands that Congress could pass a nationwide carry legislation that would require states. So I don't favor that legislation. I think states should have some federalism, some discretion. But this issue may actually arise if Congress tries to pass a national carry statute. Good question.
I know you said the original scam was kind of uncomfortable with the ultimate standard that came out. Admittedly, I thought it was a very difficult standard. The timing question was very difficult. It just ultimately grew. And I was wondering what you thought, or if you did think that there was, a better, more applicable, clearer standard. What would you have applied?
Yeah. And this might have been why Thomas did what he did. There isn't really a very good answer to that, right? And if you don't believe me, just think of the First Amendment, which is a complete hodgepodge. I think the court should have done a few things what they did. First off, is say who has the burden, right? A number of lower courts place the burden on the person seeking the gun license. And when you place the burden on the person seeking the right, they're probably going to lose, because there's always things that they don't consider. But by placing the burden on the government, that's actually a very significant step, because the government must show, not just in general, but in this particular case, why this person should not have a gun. I think another thing the court did that was important was saying that you can't require some sort of special justification to carry a gun. If the court had just said those two things, right? They said, okay, we're going to use something like strict scrutiny where the burden's on the government, and you can't require some sort of special justification, that would have been a victory. And the plaintiffs would have won. But Justice Thomas didn't want to do that. And I'll pause why. I think Thomas has sort of been frustrated for a decade that you have all these states or these state courts flattening their nose at Heller and McDonald. So Tom's like, okay, you want to play? I'll play. I'm going to give you a test, but you're going to have to follow. And you have to do some hard work on this. You can't just brush these cases off under intermediate scrutiny. So I think that's why we got what we got with Bruin. But I don't have a terribly good answer for this. I didn't file an amicus in this case. I don't have personal thoughts, but it's a very hard answer. Good question. Yeah.
So I have a question, and you touched on this a little bit at the very end of your talk, but specifically rights that are kind of incorporated against the states. Do you anticipate that the Bruin standard might, start being used in other contexts, like specifically maybe even in the First Amendment context? And it's like, will the Glucksberg test survive?
Make Washington v. Luxembourg great again, right? So let me just give some background in case you aren't familiar. Generally, the Supreme Court's held that whatever right exists, whether it's applied to the federal government or the state government, has the same scope. Justice Harlan didn't agree with that, but he lost out about 5 decades ago. Assuming that the Second Amendment is this strong standard, then we ask, how does that bleed over to other areas of the law, right? The First Amendment, you guys take First Amendment as a required class, or at least optional? No. The First Amendment is a complete mess, right? There are, I'm not joking you, dozens of tests to use in different contexts, and the people are nodding. And keeping track of them is very hard. There's intermediate scrutiny, time, place, and manner, strict scrutiny, right? There are all these different incitement, there are all these different tests that don't cohere. And none of these tests were created with regard to original meaning. They're all sort of just made up over the time by the Warren Court and so on. If Justice Thomas has this one line in Bruin, he says, well, the First Amendment's historical. Really? That's news to me, right? If we start actually extending Bruin to other contexts, a lot of things go away. So I'll use a contemporary example. New York Times versus Sullivan. Actual malice. Supreme Court kind of just made that up. I mean, there is historical concern about seditious libel, right? But the actual standard, which is very important today, is gone. And let me tell you, not everyone likes the actual malice test. People want to make it easier to sue media publications. What else on the chopping block? Pornography and obscenity, right? The idea that pornography is protected by the First Amendment. Adult dancing. Are these really going to be held up by history, right? Until the Warren Court, no one even thought you had a right to engage in indecent displays in public. So if the court goes down this road, a lot of things will be upset. I don't think they will, but it could be very disturbing of the force, if you will. Get someone else to ask a question. Yeah, up front.
How do you think that Bruin's going to impact gun rights for people with mental health issues, and like how, like somebody who just went with like a therapist?
It's right. It's real. I mean, and I want to approach this question very delicately because I think it's a delicate topic. Mental health is complicated, right? I think we know more about this issue today than even did 3 or 4 years ago. People see mental health professionals for a lot of reasons. Maybe they're under treatment for some period of time that ends because it's successful. Maybe they have different regimes of treatment. People have relapses. There are a lot of things. I am very nervous about the government saying, oh, well, you had a diagnosis of depression 25 years ago and you took Prozac for a few months. And you know what? I think you're not worthy of having a gun, right? Even if you hate guns, that sort of leafing through your medical history is tricky. What if your doctor is retired or dead and who's even going to speak about your record, right? These records don't exist. Oh, you don't have any, no one will test your mental health 20 years ago, you don't get a gun. I think the indicia has to be one of dangerousness, right? There has to be some finding that the government has that you're dangerous. A lot of people with mental health are actually more likely to be a victim than the aggressor, to Shiz's question a few minutes ago, right? If you are someone who has these sort of health conditions, you might be in need of self-defense. But these are hard issues. And Kavanaugh sort of aside, oh yeah, mental health checks, you sort of just threw that in there without any thought. That I think will be problematic. Okay, maybe one more question.
Time for one more potential.
Yeah, in the back, go ahead.
So how would you expect like new firearm technologies like bump stocks or binary triggers or pistol braces to be effective under Bruin? Like, would it be like a new, like their own standard be decided by laws? Because there's no historical.
Right. Yeah. I mean, a bump stock didn't exist 15 years ago, right? And I actually, in full disclosure, I litigate 3D printed gun issues. This is something I litigate on the side among my many activities. I don't think Bruin says anything about that, right? I think Bruin is more concerned about carrying restrictions, not the types of weapons you can carry. Bans on novel types of weapons like a bump stock perhaps be analogized to the long-standing ban on machine guns, which, go pew, 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 you hold one button, it goes rapid fire. But then again, those laws themselves were novel. People didn't really contest them in the 1930s. So I don't know that there's a good answer on rapid fire and bump stocks. The bump stock issue is actually one of the APA and the National Firearms Act, right? Does the National Firearms Act actually give the government the power to ban a bump stock? I don't think it does, but there's a cert petition pending right now on that exact issue. I think we're out of time.
Great. Well, thank you all.
Thank you so much. Thank you. I'm happy to answer any questions